So welcome to today's session for Law for Community Workers on protection visas. We have Devni, who's a solicitor in the immigration law team, joining us today as our presenter. And I am joining you from Legal Aid's head office in Haymarket in Sydney. That's on the Gadigal land of the Eora Nation, and we would like to pay our respects to the custodians of the lands on which we're all joining from today, and thank Aboriginal and Torres Strait Islander people for their ongoing stewardship and education on how best to care for these beautiful lands, seas and communities that we're all very privileged to share in. As always, with the Law for Community Workers series, this will be uploaded to YouTube. So just a disclaimer, this is an information session providing a general overview. It's not specific legal advice. It's not to be taken as such. If you would like to get legal advice, or if you're a person who's watching this in the future, Law Access is the number that you can contact for advice and referrals into legal aid. So today's episode comes as part of perhaps like a series that we've done. We've done some past immigration law episodes. There's one on protection visas. I will provide you with the links to this after the webinar has finished, and I'll send this link through. So Devni, I'm about to hand over to you. Would you like to introduce yourself? And also introduce Jess, who's going to be joining us in a bit for answering questions at the end.
Good afternoon, everyone. My name's Devni Walpola. I'm a solicitor in the immigration team here at Legal Aid New South Wales. I also have here my colleague Jessica Schulman, who's the senior solicitor, the immigration team here at Legal Aid New South Wales, and she'll be able to help with answering any questions you may have. So I'm joining here today also from the Legal Aid office in Sydney on Gadigal land, and wish to pay my respects to elders past and present. So today I'll be speaking to you about protection visas at the primary stage. In this session, I'll be covering a fair bit. First, I'll be speaking about legal aid and specifically the role of the immigration team and what we do here at Legal Aid. I'll be covering the basics of protection visas, key definitions, how to apply for a protection visa, what to expect from the process, and how to refer clients who need advice or assistance with their protection visa application. I will also touch on refusals at the ART, but because my colleague Hannah has already covered this topic in quite a bit of depth in a previous webinar, which can be found on the Legal Aid YouTube page, and I believe Helen will also be popping that into the chat for you guys to be able to take a look at later if you'd like for further research. If you have any questions, please feel free to pop them in the chat. Helen will be facilitating those questions. And so will my colleague Jessica. She'll be able to help with answering some of those questions. Next slide, please. Oh, actually, sorry. Keep it back on the last slide. Yep. Thanks. And yeah, so immigration team at Legal Aid is a free legal service that advises and represents on immigration and citizenship matters for New South Wales residents. Legal Aid New South Wales provides free legal advice to everyone in New South Wales. So a person does not need to be a citizen or permanent resident to get legal advice from New South Wales. If you go to the next screen, please, Helen. You'll be able to see some of the services that we provide to clients and what we can give them advice about. So visa cancellations, citizenship applications for refugees, protection visas, and family violence where it affects the person's visa status. Everything that people tell Legal Aid is confidential. Well, tell legal aid lawyers, confidential. This means that we can't tell anyone what a client says or gives to us unless they agree to it being shared. Next slide, please, Helen. Here are the contact details to get in touch with us if you need to make any referrals for protection visa advice. Both our phone and email are listed there, and you can find through the website as well ways to get in touch with us. Next slide, please, Helen. So what is a protection visa? To start off, a protection visa is granted to individuals who are at risk of harm or persecution in their home country and are found to be owed protection. These are sometimes referred to as refugee visas. For the purpose of this presentation, I will focus on the permanent protection visa known as the 866 visa. This visa is for protection applicants that hold a visa in Australia and have arrived to Australia by plane. Otherwise, there are two types of temporary visas, known as, you may have heard, the TPV and SHEV. TPV stands for Temporary Protection Visa and SHEV, Safe Haven Enterprise Visa. If you're an applicant that has arrived in Australia without a visa, usually by boat, this is likely the visa you would be on. And then there's the Resolution of Status 851 visa, otherwise known as ROS. This visa was introduced in 2023 and provided a long-awaited pathway to permanency for TPV and SHEV visa holders. Next slide, please, Han. So how does one get a protection visa? They have to satisfy protection criteria and satisfy to immigration that either you are a refugee, or if not, that you are owed complementary protection, or are a member of the same family unit of someone who is a refugee or who is owed complementary protection. Next slide, please, Helen. So the definitions. So who is refugee? This is defined in international law. The 1951 Refugee Convention defines refugee as a person who is outside of their country of nationality and, owing to a well-founded fear of persecution, is unable or unwilling to avail themselves of the protection of that country. Australia is a signatory to the Refugee Convention. Therefore, we have obligations we have to abide by under it. There may be a real chance of persecution for one of the 5 convention reasons listed there: race, religion, nationality, membership of a particular social group, or political opinion. In terms of what real chance means, this doesn't have to be 100% chance. It can be as little as a 10% chance. And it is comprised of objective and subjective elements. The real chance has to apply to all areas of a home country. So it has to be the case that you can't move to another part of the country safely. Also, state protection is not available, meaning that government institutions can't protect you. So, for example, the police. You also cannot take reasonable steps to modify your behavior. So, for example, it's not reasonable to have to change your religion or change your sexuality or gender, but it may be reasonable to, say, change your employment. Next slide, please, Helen. So the definition of complementary protection. So not everybody falls under the refugee definition. So if an applicant does not meet the refugee definition, then they may meet the complementary protection criteria if they can establish that they suffer certain types of harm which engage Australia's other protection obligations found in the Convention Against Torture and the International Covenant on Civil and Political Rights. A person can be granted a protection visa on the basis of complementary protection if there are substantial grounds for believing that there is a real risk that the person will suffer significant harm if they were removed from Australia to their home country. Significant harm means the death penalty, arbitrary deprivation of life, torture, cruel and inhumane treatment, and degrading treatment. It is not considered to be a real risk that a person will suffer significant harm if it would be reasonable for them to relocate to an area of the country where there would not be a real risk that they will suffer significant harm, or that they could obtain protection from the state, or that the real risk is one faced by the population of the country generally and not faced by them personally. So, for example, in the case of civil war or conflict, fear would be faced likely by the population and not personally by the individual, and therefore it can be difficult to meet this definition in that kind of circumstance. And so now we're moving on to the application process itself. Thank you, Helen. The protection visa application must be made through an IMI account online. This is the platform for the Department of Home Affairs that's present for lodging visa applications, unless there is permission provided specifically from the Department of Home Affairs to lodge a paper form. The cost of the protection visa application is $45. The protection visa application includes evidence of identity documents, family history, travel history, education, and work experience. It comprises around 110 questions and is only available in English. Understandably, this presents a huge barrier for many non-English speaking clients or even clients with cognitive or mental health challenges. The application process also involves providing a detailed statement of claims on fears of harm and providing evidence of claims, which I'll talk about in the next slide. So a statement of claims essentially means a detailed summary of a client's account. This is an opportunity for a client to give as much detail as possible about their fears of returning to their home country and explain the circumstances of leaving their home country too. So, for example, why and when they left, details like that. It is important to state whether the applicant has a right to reside in another country or if they have multiple nationalities here as well. The applicant will be questioned in quite a bit of detail about the statement in the interview. The focus is on the client's personal situation and not problems faced by others in their home country. That's important to note as well. If applicable, it's also an opportunity to provide supporting documents that correspond with the statement. You may also need to get translations of these documents if they're in another language. And that could be done often through NATI, which is a National Accreditation Authority for Translators and Interpreters. In terms of important tips, keep in mind with the statement of claims, really important for it to be in chronological order. This will make it easy for anyone reading it, especially the department, to follow. As well, consistency. This is important for the department's assessment of the applicant's credibility. Here, it's helpful to check that the statement is consistent with the information provided within the application, as well as in previous visa applications where the client may have previously held a visa. This is an opportunity where it would be helpful to submit an online form through the department to get a full request of the file if the client doesn't already have copies of it. And this is a good way to assist your client through that. Getting a copy of the department file will help to check the dates against other documents as well. It's also really important to be honest. Clients should be warned against giving false or misleading information, and this applies to all visas in Australia. Thank you. Next slide, please. So as you could probably tell, our clients really do face multiple and overlapping barriers and vulnerabilities through that protection visa application process. This can include issues like internet and computer access, English literacy, level of education, cognitive, mental, or physical health barriers, and being socially isolated. People who are afraid to return to their home country are often at a point of crisis. And so combined with these other barriers, this can be a really daunting process. Sometimes also in terms of socialization, isolation, clients can fear information may travel back to their home country as well. The character questions as well can be really convoluted in the protection visa application. So it can be very easy to misunderstand a question. And of course, that can have serious consequences as well. It's also really easy to unintentionally make a mistake. So for example, not including maybe the correct date of birth of a sibling when you've got maybe 6 of them. And so there was probably no intention for the client to be evasive in an example like that. The application process can often be really daunting, and so having support through that would be an amazing thing to have with you all. Next slide, please. Um, so this is a really important slide because we've seen it time and time again where quite critical correspondence has been missed by a client where they had not kept their contact details up to date with the department. So it's really, really important to help clients keep their contact details up to date, and that can be done through their IMI account. Examples where challenges can arise with keeping details up to date or missing correspondence include when clients have changed their phone numbers or they have moved around, which is often the case with many of our vulnerable clients who maybe can't afford housing, um, especially if clients are facing homelessness. Then they also probably have barriers with access to things like phone, emails, and an address to list really with the department as well. If you are receiving documents for a client, it's really important to understand the risks associated with that. Um, if the circumstances are such that there's no way for the client to receive the correspondence directly, and you have to receive them on their behalf, it's really important to make sure the client knows if, for example, you go on leave or you leave your role. Um, Important emails that the client could receive about their application can include emails about biometrics. So if they miss their biometrics appointment, this can mean an invalid application. And so it's really important um, when getting that letter to follow it and bring the details needed for the appointment, which usually is your passport. Another example of an important email a client could miss is an interview date, and that could be really critical to the outcome of the application, as well as requests for further information. And this is where the department needs further details or evidence, as it suggests. And it could be quite important detail that the department needs to make a decision on the application. Um, Next slide, please. So the protection visa interview. Um, the protection visa interview will usually be held over video. If an interpreter is needed, it's important to let the department know before. It's also really helpful to let the department know if the client's having difficulties with the interpreter during the actual interview itself. If the client wants a support person, they're welcome to have them come attend the interview with them. It would just be great to let the department know before the interview. Prior to the interview, it is important that a client is comfortable with their protection visa application and statements and that they know it really well. Not all applicants will get an interview. So making sure that all the evidence you want to rely on is lodged with immigration is quite key. Um, in terms of ways you can support your client in the process of the interview, in addition to going over statements and applications with them to make sure they're familiar with them, could be having conversations with your client about their emotions around the interview. It can be quite a daunting process, often just waiting for an interview. So um, also just making sure that they have copies of all the documents relevant to them for the interview. Yeah. And also a support letter is another way you can help. This can be provided before or after an interview from yourself as well to support the client's application. Next slide, please. If refused by the department, there's still options. They can apply for review at the Administrative Review Tribunal. Best way to do that would be online. The Administrative Review Tribunal will have a fresh look at the merits of this case, and it's usually the last chance to present their case, really. The deadline for applying to the tribunal is 28 days if your client's in the community, or 14 working days if they're in detention. You can find this on the notification letter as well. This is what's important to know is that this is a very hard deadline and they will lose their right to appeal if they miss it. So extensions are just not possible. Um, there's also no fee to apply to the tribunal, but if they lose, they will have to pay a fee of over $1,700. If they lose at the tribunal, only judicial review is available after this stage. Next slide, please, Helen. So if what refusal options there are when refused. The department basically, this means that when a client has been refused a protection visa, they are Section 48 barred, which means essentially they have very limited further visa application pathways open to them, other than a partner visa if, say, the circumstances and money are present for that's their situation. They cannot apply for a protection visa again unless they are successful at the ministerial intervention stage or judicial review. So with judicial review, that's when you are refused by the tribunal and there's 35 days to apply. It's quite difficult to apply after those 35 days unless there's grounds for application for extension of time. So really, it's quite important at this stage for, as many other stages, but it's quite important at this stage to get legal advice before applying or after applying. At this stage, the court doesn't consider merits. It's only new claims. It's not no new claims, no country information. It's really only a narrow form of review based on legal error. So at this stage, if you've got a client who's been refused at the tribunal, make sure that you get them referred for legal advice and provide that negative decision at the tribunal so we can have a look at it. Be also helpful to get a court book to us if they've applied for judicial review as well. And then in terms of ministerial intervention, this is a pathway, though it's quite limited and difficult at times. It is an option once options have really been exhausted and there needs to be new information about your case or that there have been significant changes in circumstances since protection visa refusal. And finally, an option that is definitely difficult to talk about, but sometimes there's no other option when all possibilities have been exhausted, and that is considering return to home country. And an important thing to know here before I move on is that the bridging visa will expire 35 days after the refusal of the tribunal. So it's really important to get in your client as soon as possible to get some legal advice so they know what to do next. Thank you. Next slide. So we've got here just a few examples of typical client profile that we see here as lawyers at Legal Aid. We often assist clients who are women and are afraid to return to their home country, for example, due to domestic violence from their partner in their home country or sexual gender-based violence in their home country. We often also see clients that have left their home country where their partner lived and they experienced domestic violence in their home country. And once coming to Australia, say another visa, they apply for protection visa here in Australia. We also see situations where circumstances have changed since arriving in Australia on another visa. We see cases where clients present who are pregnant or who have had a child out of wedlock and fear returning to their home country where they fear they'll face harm. Another example is an applicant that may have separated from their ex-partner due to domestic violence that they've experienced in Australia, and their ex-partner has now returned to their home country, and maybe they or even their family cannot accept the separation. And the applicant may be receiving threats or other examples of reasons why they fear returning home to their home country. Next slide, please. Hello. So ways that you can support your client, multitude of ways really, but often there can be so many documents to navigate. So really helping a client organize the documents, keep on top of it, helping a client with providing a support letter for their interview or for their hearing. That can also be really helpful. Helping a client with managing more appointments. Sometimes they could be having various appointments, whether that's with social workers, psychologists, etc. So just making sure that they're keeping on top of it, that'd be always really helpful. Attending interviews or hearings as a support person, as we discussed before. Um, and a main one really is with managing the wait times for an interview, hearing, and outcome. This can be a really emotionally exhausting process where clients can sometimes be waiting up to several years, both at the tribunal and department stages. So managing those waiting periods really, and as well managing possible refusals and the impact emotionally of those refusals as well. Um, as well as assisting clients with accessing services. A common one we see is a client that maybe wants to apply or renew their Medicare. So helping clients with that as well is definitely a way that you can help. Next slide, please. Thank you. In terms of services, these are just some that come to mind. I realize I missed one actually, so I'll start with that, and that is Asylum Seeker Centre. They're a really, really great resource. They're located in Newtown, provide many different types of supports to refugees and asylum seekers. Um, and I was also going to mention here actually that if you have any other services that you don't see here on the page that you think others might benefit from, we'd be happy to maybe circulate some around or list them out today, because it's always really helpful when we get gatherings like this, because we can definitely learn from each other. So examples as I described before: Medicare, refugee health service, if the client doesn't have access to Medicare. Then in terms of housing, that can sometimes be limited for those on temporary visas. And that would be the case for clients maybe who are on bridging visas while waiting for protection visa. So it could help to advocate for your client with crisis accommodations, but also acknowledging that it might be quite limited as well. But you can contact DV hotline or link to home, respectively, depending on the situation of the client. As well, community living support for refugees is another great resource for mental health support for refugees. There's one in, I think, every LHD. And then as well, we've got SSI and Life Without Barriers. They do a lot of assistance with things like status resolution, income payments, and the like. So yeah, if you have any others, feel free to pop them into chat. Next slide, please, Helen. Information that's helpful to provide with a referral. We often get asked this question from you guys and wanting to know what's the best information to provide to improve referrals. And, starting with the basics, details of the client, full name, date of birth, same thing with partners, children, would help to have the contact details and also to specify the best and safest way to contact the client. It would be also helpful to include questions that the client may have. If a date of expiry of a visa is relevant and applicable, then please also include that. It's be really, really helpful because then we can know how to prioritize those deadlines. So it'd be really, really good to include those if they are applicable. And as well, providing documents related to the applicant's visa would be really great if you have any. Yeah. Thank you. Next slide, please. And here we have an image of all the contact details for Legal Aid, IARC, and RACS. These are the 3 free legal services in New South Wales for protection visa advice and assistance. We may refer your client to one of these other fantastic services, IARC and RACS. We work with them closely, and yeah, that's we'd refer them if we don't have capacity. So yeah, If you want to leave it for a couple minutes, take down those notes, feel free to. But
And
you can.
I'll also provide these links to you when
Yeah,
we send out the email to the registrants afterwards, everybody. So you'll get a copy of those in your inbox.
amazing. Thanks, Helen. That'd be great. Yeah, so that's about it really. Just also have on the next page the law access contact details, so you can access that through our website. And even if you want to refer clients for advice outside of immigration that they might need some legal help with. So and then finally, last slide, if in doubt at all, just refer your client to get some legal advice. Yeah. Thank you so much. And open up to any other questions that you guys might have as well.
Thank you, Devni. All right. Well, anyone using the Q&A box, if anyone would like to ask a question, you can ask it anonymously. Please go ahead. We've got Jess here, who's an experienced senior solicitor, to also assist with any curly ones. So we'll just give it a moment and see if anyone's got any questions. There were a couple that came in during the course of the session, which Jess has jumped onto and answered, which you can see in the Q&A box itself.
A couple of the questions that I've just received now that I'll answer verbally. Can clients self-refer? They absolutely can. There's no wrong door at Legal Aid. We would recommend providing the law access number to clients where they can speak with someone from the law access team who can determine the best pathway for them to get legal advice. And what we often find is that a lot of our clients have multiple legal issues. So they may have an immigration issue, they may have a family law issue, they may have a criminal issue or another civil issue. So that's usually the best way moving forward. Oh my goodness, they are coming hard and fast. What is the likelihood of a minister's approval after refusal by the tribunal? I think that this question is in relation to ministerial intervention. Ministerial intervention is only available in circumstances where a person has been double refused, is probably the best way to explain it, where they've had a refusal by the Department of Immigration of their visa application, they've applied for a review, and at the tribunal that review has been affirmed. That decision to refuse their visa has been affirmed, and only at that point can they write to the Minister for Immigration under the Minister's public interest powers and seek the Minister's intervention to be granted another visa. In those circumstances, the chances of the Minister intervening are extremely low. The Minister's powers are non-compellable as well, so you cannot compel the minister to consider the case. Yeah, I guess that's what I can say about it. There is another ministerial power under Section 48, allowing the minister can intervene, allowing a person to apply for another protection visa application if seeking ministerial intervention under Section 48B of the Migration Act. That person doesn't have to go through review before they can write to the minister. In those circumstances, that person would need to show that they have new claims, new information that wasn't originally considered in their original protection visa application. Navi's asked whether clients have to register for the SRSS program. And look, I'm not sure. I don't know the answer to that. I think you may need to speak with, probably the best way forward would be to speak with, Helen might be able to answer that question. I'll leave that with Helen.
Oh, sorry, no, I was just doing something in the background there, Jess.
Okay, sure.
Sorry to disturb you.
I think it may be best to speak with an SRSS provider to determine what the steps are to referring or accessing SRSS. If you have any specific individual questions relating to ministerial intervention or really anything that Devni's spoken about today, please feel free to contact Law Access or contact the immigration team at Legal Aid, and we will do our best. to help you out.
So it sounds like, Jess, that there's a few questions that have come up during the course of this around, what can we expect by way of wait times? What's the background intel on that? And you've responded to a few people, and perhaps is also related to something that someone's asked here about how many cases are successful. It seems like is it a very case by case situation, and it can be very difficult to give any set timeframes on these things. Is that your experience?
Absolutely. And what you'll find is you can actually check global processing times on the Department of Immigration's website for most visa applications. So for partner visas or for skilled visas or even for citizenship matters, the global processing times can tell you the average processing time for each individual type of visa subclass. Unfortunately, protection visas are not included, so you won't find that information on the Department of Immigration's website. However, the FOI logs are readily publicly available on the Department of Immigration's website. And that is where I actually got that information, where I said in 2022 to 2023, the average processing time for a protection visa application was 1,052 days. However, it is incredibly relative and really depends on the individual application and the claims. We have seen matters processed in a very short amount of time. It also depends if a client is in immigration detention or in the community. Detention matters are usually considered much quicker than people who are in the community. So it really depends on a variety of factors. It is very fact specific.
Yeah. And while we're talking about, I guess, the uncertainties of the timeframes, etc., I also just wanted to flag, which Jess had reminded me of, that this episode today, the 3rd of July 2025, laws do change over time. So while this is all relevant and up-to-date information today, it is an area that does have changes to it. So just be aware that, everything we've talked about today is obviously going to be subject to perhaps needing to be updated in the future.
Yes, I think Devni and I would absolutely agree. It is an ever-changing space, and we would always recommend that everyone gets legal advice before they embark on applying for a protection visa, and get advice at every stage of their application as well.
And if you would like to have a copy of these PowerPoint slides, just reach out to us at the CLE team and let us know that if you'd like a copy, we're happy to provide that. But also on the understanding that these things may need to change in the future. So always the best route is to, like it says at the bottom here, if in doubt, get legal advice and ask for your client to speak to someone in the immigration team at Legal Aid. Legal Aid helpline is, yes, it's actually 9 to 5, Monday to Friday. That's the Law Access telephone number that was on the previous slide. And that's one of the ways to contact us in the immigration team. Do you have a particular preference of when community workers or clients should call?
No, we don't. Our phones are manned 9 a.m. till 5 p.m. I think there is also the facility to leave a message if your call is not answered.
That's great. All right. Well, there haven't been. Oh, sorry. Another question. Is it best to send materials via email? How would you like to receive the referral information that we talked about earlier?
Devni,
Yeah, I think email would probably be. Yeah.
Did one of the slides have our email address?
Yeah. If we can go back maybe to, there we go. That one on the bottom left would be probably the email to send through. Yep.
immigrationreferrals@legalaid.nsw.gov.au is an email for community support workers to refer clients to us. If you are referring a client, please provide as much information as possible and include any correspondence, any visa grant notices, any deadlines, any decision records, whatever you can collect from the client. And if you can provide that to us, because that's going to help us determine the urgency of the matter and help us triage it effectively.
Jess, there's one other question that's come through here about what happens if someone gives birth. The scenario is that child also going to be on the visa, or what's the status there?
That's a really good question, and it is fact specific, and I would strongly recommend that those clients get legal advice as soon as possible about the status of that child. That is the kind of advice that our team would provide.
Right. And there's another one here. Do you mind just to have a look in the box? It's about the ministerial intervention request.
Yeah, I think there's been a couple of questions similar to this. What are the chances of success at the minister? I don't want to give a percentage. I don't know the percentage, but what I can tell you is that it's a very small percentage of matters that are where the minister will intervene positively in a client's case. I guess that's the best that I can put. Yeah. I hope that I can put it.
Thank you so much. So unless there's anything further, I think I just wanted to thank again Devni and Jess for answering the questions and the work that you do as well. It's really great to have had all of you as well joining with us today, community workers. And there is another unrelated webinar that's coming up this month. It's about property changes in family law. And you will be receiving a survey at the end of this session today, and we would appreciate if you could fill it out and give us some feedback, and also if you had any suggestions for future topics that you would like to hear about that are relevant to your work that we can assist, would put those on the agenda. So once again, thank you, Devni and Jess. We hope that you all have a great lunch break, and this episode will be uploaded to Legal Aid's YouTube channel, and you'll be receiving an email likely tomorrow with links to that we've gone through today about how to get in touch with us. So yeah, thank you everybody.
Thank you, everyone.